the Russian country map, which is going to be presented by Professor Vadim Volkov, Professor Arina Dmitrieva, and Professor Dmitry Sklobarevsky. And the paper will be commented by Professor Sari Graben and Professor Rafael Maffei. And also we have now, we are testing a new technology as a conference over Skype with Professor Nadine from Toronto, right? From Montreal, sorry. And it's very nice to have you here, Professor Nadini. Hi. And this is not good technology because it makes conference not necessary anymore, and we really like conference. So don't pay attention to this technology. Don't pay much attention to that, please. But just joking. I'm very happy to have you here. So please start your presentation, and Professor Nadine will be the last one. Okay.
Works. Yeah. Good morning. We are very happy to be here in the southern hemisphere, having traveled from -5 to +30. So we do feel this contrast and warm reception in all respects. Thanks very much for inviting us. What I will present is there will be two presenters. I will present the first part and Dmitry will present the second part, but that's the result of our concerted effort. So let me begin the Russian exposition from the very simple fact. Russia is governed by Soviet law school graduates. And a large part of the Russian political elite are the graduates of just one department of Leningrad State University Law Department. And if you enter this department, you have a gallery of portraits of people who now serve in the government, presidential administration, general procuracy, investigative committee. All of them are presented there, and all graduated from this faculty. So nobody really made an effort to study what were they taught. I mean, what were those ideas and understandings of law that were imprinted upon them when they were students. So of course including Vladimir Putin and Dmitry Medvedev, who were graduates of the same school. So some sort of legal attitude and understanding is there, and that's basically Soviet and early post-Soviet attitude. Now, I just found in the news, it's the yesterday's news quote from Vladimir Putin, who met the judges of the Constitutional Court, and he said, and it was publicly quoted, "I consider Russian legal and judicial system one of the most developed in the world." So this is the way, or at least this is their vision, and this is at least the way they declare their attitude. So the plan of my our presentation is this. First, I will give a general context in which law and development studies operate in Russia. Then we'll look closer at what do they look like. Then we focus on connections with policy and see successes and failures assess successes and failures of law and development, and then a few questions for the future. So the general picture. So the Russian regime can be surely qualified as ruled by law. And moreover, it's complicated by very heavy political legalism. Political legalism means that virtually all policy decisions take the form of law or amendments to law. there is discourse that everything should be according to the law. Which means that all government decisions, all political decisions have to be legitimated by the legal form. That actually creates an abuse of law in a peculiar way. We have too much law. In combination with the domination of one party in the legislature, the legislative process can be very quick and actually is a projection of the will of the executive power. In fact, nowadays law becomes the universal means of solving any problem. Okay, you want to improve the health of the population and make them stop smoke. You draft and accept the law on smoking bans. Or you want to regulate moral standards. There's an anti-homosexual propaganda law, or the censorship of the internet. You want to fight capital flight? Easy. You pass the law or restricting the offshore foreign ownership of Russian companies. You want to regulate migration? Fine, you just suggest another law. And actually it takes 1 or 2 months for a law to be passed. There are three stages before it is submitted to the president for his signature, and so forth. So that leads to hyperactive legislative activity. And the state Duma, the parliament, passes for more than 400 federal laws per year. So naturally that results in a very poor quality of laws. And then once this poor quality of laws and contradiction within the texts of law or undesired effects are discovered, then the natural reaction is amending the laws. So there's a constant activity of discussing and adopting amendments to laws, which then, of course, makes the legal environment quite adverse to many sorts of activities, because laws, they constantly change, and these changes are hard to predict. The density of regulatory environment is very high, it's excessive, and it combines with uncertainty. However, this then is compensated by the problems of application of law and law enforcement. So many laws, they just become not effective because they cannot be adequately enforced, which leads to the situation that benefits executive powers again, because in the situation of the changing laws, it's up to the controlling and law enforcement and regulation agencies and their policies it depends upon how actively they enforce this or that law, upon their capacity and upon their organizational and corporate interests. Now, quickly, the general developmental context. As you know, until recently, Russia accumulated large flows of export revenue incomes. They were accumulated primarily in the federal budget and by the large state-controlled corporations. So it naturally brought back the developmental state, and the agenda focused around state expenditures and state investments. And the development policy was the creation of national champions, that is, large companies that are able of kind of global influence, like Gazprom or United Aircraft Building Corporation, and so forth. Then federal programs and public contracts, the creations of what is called institutions of development, large state banks capitalized by, by the state, and then they offer loans and credits to private and public sector, for example, for infrastructural construction or R&D. And a very peculiar legal invention, statute corporations. For example, in order to handle the Olympic, the 2013 Olympic construction, a special corporation was created and endowed with up to $20 billion to construct the Olympic infrastructure. Well, it leaves the private sector with resources of international markets, dependent upon the government in relational relational governance, and actually boosting the consumer, the import sector. Another important trend is juridization of state and civil society. In fact, large investments were made in the 2000s in the development of the judicial system, both commercial courts, commercial arbitration courts, and courts of general jurisdiction. The number of judges, this line, the number of judges doubled over a decade since 2000, and the number of cases more than tripled. And that especially refers to civil cases where citizens themselves go to court and brought their disputes to court. So the demand for law went up, and the Russian judicial system was in the position to meet this demand, or it generated this demand because its performance objectively improved. And especially dramatic improvement took place in the system of arbitration court, where corporate entities and public entities submit their cases. So it is in this context that law and development studies should be analyzed. Now, the first important matter is the separation of practice and theory in law and development studies. In fact, the law and development studies, or the field, has been developing steadily and intensely in Russia, although the paradigm of law and development, as it is discussed here, was never articulated. Instead, law and development practice first of all took the form of regulatory impact assessment. And even this practice was almost transformed into a law by means of government decree that made regulatory impact assessment of any legislative act compulsory. This is basically the resistance of the Ministry of Development and Trade to the uncontrolled legislative and poor legislative activity of the state legislature. Okay, you're going to print those laws, but then we're going to subject it to expertise. And that, in turn, led to the proliferation of centers and think tanks that offer their expertise in regulatory impact assessment, with special focus on things like antitrust legislation, for example, or regulation of trade. And there are at least 3 powerful centers of that activity: the Academy of Public Services in Moscow, the Bureau of Economic Analysis, and the High School of Economics. What about theory? There is no theory as it is discussed here. Instead, of that, it's institutions and economic growth, which is the new institutional orthodoxy with its usual discourse of low transaction costs, productivity of proper rights, which is very theoretical, very doctrinal, and lacks empirical evidence, since most of the empirical evidence in new institutionalism comes from, you know, early to late modern times, Western countries. But in fact, it had some good practical effects. Since this discussion of Douglas North and new institutionalism was focused in Russia upon the state, there's a notion of path dependency in this theory, and specific Russian path dependency was recognized as the historical and excessive historical strength and overdevelopment of the state that can be either a powerful locomotive of development at any cost, but that can be also the force that suppresses and destroys economic development. So within the framework of this debate, applied and policy-oriented discussion was directed to the issues of the use of criminal laws and the behavior of law enforcement agencies that had adverse effects on the private sector, that is, the pressure upon the private business. And the criminal code was the criminal code was recognized as the major means of regulating civil or economic relations, and that was then translated into public debate and expert pressure on the government, which reacted in 2009-2011 by the softening by legislative amendments, softening on economic, the sanction for economic crimes, and putting additional constraints on the behavior of law enforcement agencies that are in charge of enforcing economic and tax crimes. And again, this High School of Economics and Moscow State University would be the intellectual centers of this activity. Now, what is missing from this focus is the sociology of law, empirical legal studies, and law in action. The studies and the research of those agencies that are responsible for interpreting and applying, enforcing the law, that are responsible for transforming the law on paper into the law in action. Basically, that are very much responsible for the real, actual effects of law in Russia. This is basically the paradigm in which our institution works. So law is nothing, the application of law is everything. So we have to understand how law is applied in practice. To understand that, we have to understand the rules that govern the application of laws, because no law applies itself, and all laws are principally open to interpretation and open to arbitrary application, unless a sound tradition of their application is developed, which is not the case in many instances because of intense legal innovation. So instead of that, we have then to look at institutional incentives, organization of regulation and law enforcing agencies that basically generate the logic of enforcement or non-enforcement of laws. So, and that's the domain proper of sociology of law, or organizational sociology. So that's our main focus. I will not go into much detail. I could present it maybe later because we're short of time. But actually, I do agree that what is really missing in law and development studies, and that's what we try to compensate for, is the sound empirical evidence and empirically oriented research that would actually convince and find the links between law and development, improve, articulate, and then transform into policy recommendations. So we are very much empirically oriented. We, I believe, have the largest data set in the world of the largest data set of court decisions, the 5 million data set. We have a large base of interviews with judges and law enforcers. We do conduct a lot of empirical work with police and judges. Then what we are focused upon is this policy of gradual local improvements based on comprehensive study of the mechanisms of the functioning of the real law. So that, I believe, is the path to the development of law and development studies at present. And now I will pass the floor to Dmitry, who will give you some concrete cases.
Thank you. In my part, I will adopt a case-based approach because Russia, I think, offers a very exciting platform to study law and development because we found 3 cases where law and development either was a major success story or went disastrously bad or had an ambiguous effect. So I'll start with a success story, that is World Bank actions. Much akin to the projects in other transition economies, in 1996, World Bank started its project on legal reform, and it was funded quite well. And by allocation of funds, by the initial allocation of funds, you can see that it conformed to the consensus of the development agenda of the bank at that time. Most of the funds were channeled at improvement of quality of bills, of legislation, in particular economic laws. And 35% of funds were targeted at improving human capital and judicial awareness of new laws and so on. The results of this legal reform project were weak performance of the main component that was financed. Legal drafting component was unsuccessful or moderately successful in the terminology of the bank. Judicial training component in contrast was extremely successful, proved extremely successful, and with the power of hindsight we can say that the key feature of this legal reform act that was unintended by the bank was the information publication of acts of courts via information communication technology over the internet. So World Bank recognized the success of the second component, and in 2007 it launched a second wave of reforms. Now it was called Judicial Reform Support Project, and as you can see, the vast majority of the funds were channeled to information communication technology. And now we understand that it was the major success. To the best of our knowledge, Russia has the best court statistics system in the world. Every single case adjudicated in criminal courts is recorded in one database, federal database, which is accessible to researchers. So we, as researchers, can study sentencing decisions starting from 2009, and it's a major contribution of this very law and development field. And it's interesting to note that through information and communication technology, World Bank indirectly achieved effects on legal drafting process, because with hard data at hand on how judges actually adjudicate, one can influence legal drafting process, which concerns application of law, changes of criminal sanctions, and so on. So the main point of this project and the success of law and development in this very sphere is that in a relatively rich country with a high information penetration, high penetration of information and communication technology, it might be beneficial to target law and development on this area of improving court transparency through advanced technology. Next, a case of disastrous failure of law and development is forest code. In 2010, Russia had the most, the very disastrous fires in forests with 1,200 people dead, and here is an image of Kremlin in smoke. People suffered a lot, were displaced from their local communities because of those fires, and it turns out that those fires offer a good example of how, or bad example of how legislation went bad to provoke those fires. Because 2006 Forest Code, which was adapted 4 years before the fires took place, broke the federal authority that was charged with protecting forests, also fire guards, into 83 separate bodies, 83 regional bodies, which could hardly coordinate when this countrywide shock hit them. So Hitchcock 2011 has a wonderful account of why did it happen, why this terrible piece of legislation was made, and she notes. I refer her to. I refer you to. Yes. I refer you to the article. It's quite good. First problem was that stakeholders were not listened to. Secondly, the law itself did not provide any legal remedies for local communities, no participation. And thirdly, and I think on top of all, it was hastily made with an idea of it being a temporary bill. And I should stress that it was not a question of property rights delineation that was at the center of the code. The property rights in terms of forestry were defined in the previous code, so those changes that were made in the Forest Code of 2006 did not concern property rights, but were rather organizational. And the third case is the case of where law and development is ambiguous. I need to stress, again, the point made by Vadim on criminal law and development. I think Russia, we know that subfields of law and development, such as law and finance, law and economics at some parts, but I think Russia offers another subfield which is of interest, maybe of interest to researchers, is criminal law and development, because there is universal consensus in the country now that criminal code now is the major obstacle for economic growth. Why it happens? Because there is a big Soviet legacy in the code itself, even though it was reformed with legal transplants from other jurisdictions. However, it still remains highly regulatory, and it offers a lot of discretion for law enforcers, and the density of regulation in the code regarding economic activities is unprecedented. So criminal law is also utilized by corporate traders to change ownership, to change the title of ownership of certain businesses. And there is also formalized investigation in the country, which again leaves not much leeway for the defense side or the oppressed entrepreneurs in this very scheme where criminal law is highly oppressive and investigation is formalized. So there were some seeds of reform in this regard by ex-President Medvedev in 2010, 2011, where he tried to basically impose a special regime in the criminal code for entrepreneurs. The idea was that once we treat them well, they will be more active in economic sphere, and this will trigger economic growth. So they imposed special articles in the code for entrepreneurial crimes. They limited the use of pretrial detentions because one of the major scandals was when a lawyer of a law firm was tortured and died in pretrial detention. And there was also a 2013 amnesty, but it concerned only 2,300 people, and we do not really know what was the effect of those changes. So with a clear developmental agenda at hand of policymakers, we do not see clear outcomes and treatment effects of those changes. So I think that leaves us with an ambiguous effect of law and development in this particular case of criminal law. And I would like to end on an unrelated note with an actual call for an actual map for law and development in BRICS. Because what we found extremely interesting in our case is that most of the centers in Russia are densely located either in Moscow or in St. Petersburg, with one center in Rostov. So you can visit this link to see the map interactively now, or whenever you please. And I think a useful byproduct of this conference is to develop horizontal links between scholars in law and development, and this map can be easily extended to go beyond Russia to add Brazil, China and India to actually see who are the scholars, who are the centers, and who are the key contact persons. So I think it would be quite stimulating for horizontal engagement. So on this note, I would like to thank you for your attention and invite you.
Okay, well, thank you very much, Mariana, Dimitri, and Vadim, for an excellent presentation and review of some of the most salient issues to scholars in Russia. I'll start by saying that much like many of the people who have sat up here, when Mariana first suggested that I come on the panel, I said, but I am not a Russian scholar. And I said, what will I talk about? And she'll talk about what the linkages between you and your own research area. Because most of my focus is actually on, although it touches on some Russian indigenous communities, is indigenous interaction with regulatory environments. But what we share, and what we share quite deeply, is a socio-legal approach to regulatory analysis. And that the map and the reflection of the authors on that map reflects a similar sensitivity to the need to be attentive to the, not just how we would frame socio-legal impacts, but also the regulatory depth to which we analyze legal actors. So I'll start by a quick introduction to the map as it was discussed and provided, and implement some of the additional information that's been presented here. So the Russian map offers an important insight into what particular ways law and development studies has developed in Russia as a scholarly endeavor, and how it has been used, or more accurately failed to be used, as an instrument of policy reform to date. The authors identify key disciplinary centers, which is quite important in the map, that as relevant to development studies, law and economics, legal studies, and law and society, or socio-legal studies. So in doing so, they incorporate and use their own socio-legal approach or lens to the identification of types of disciplines that can be included under the banner of law and development for Russia, but they highlight methodological and substantive silos within which scholars which these disciplines are exercising, and that's important. What the silos seem to share is a general reflection on conceptualizing policy as tools that shape agents' actions, quote unquote. That policy tool that shapes agents' actions to match expected outcomes. And I think that that was an important statement in the map and is seen here as an identification of a general trend to have an instrumental value to policy analysis. Yet the authors express a concern that despite the instrumentalist focus of the scholarship, it's achieved actually little traction with policy actors or independent scholarly coherence, perhaps. They illustrate the effect through the 3 case studies, and then identify 3 main reasons for limited growth for development studies in Russia: the divergent opinions on the normative purpose to which policy insights are applied, difficulty reconciling development ideologies with the global South, perhaps with its identity as a northern geopolitical power, and then a shared tendency to assess law's efficacy rather than theoretical frameworks. And we see that through the discussion of the regulatory impact assessment as a tool for change. So essentially, the authors identify that focusing on policy analysis, we don't necessarily generate shared norms for policy action. And that's important. So how can we explore this insight of the authors and begin to explore the Russian experience in the context of similar experiences with using a socio-legal approach? Or extremely a contextual approach to historically and geographical specific norms. In pursuit of this question, I echo and apply the most important methodological contribution of law and development, the universalism of contextualism, and identify experimental norms that allow countries to identify the use of regulation as sites for contestation. Identify perhaps what those contests are, and identify perhaps how we identify shared norms that allow contested parties to rise above. Okay, so how do we do this? I'm going to first focus a little bit on the discussion of regulation as a methodology, and then go on to discuss how we address that through communities and sub-communities looking for law, looking for regulatory impacts, and then the role of contestation in the global north, drawing on similar experiences with development and regulatory impact or regulatory structures as a tool for development. Okay, focusing on regulation. So what we've seen here on the emphasis of the Russian scholarship on regulation and especially the regulatory effects of economic law reflect a unique and historically specific case of how regulation impacts development. But it's one that fits neatly into the global need to be attuned to the way that the minutiae of regulatory structures have been used as a tool of development. Why look at the technical aspects of regulation? In the Russian context, the need to foster perhaps rule of law type of initiatives remains a critical challenge to growth and, of course, basic justice. So while we may debate what we mean by rule of law, the fundamental flaws of ineffective limits on government powers, corruption, and ineffective regulatory enforcement seem like the key factual failings that require some response. So much as the Russian map focuses on the detailed regulatory structures of development, i.e. forestry codes, the international turn to debating the details of regulation and regulatory structures is also indisputably linked to assessments that have permeated the law and development project and indicate the need for efficacy as well as justice. Even, however, if we can trace the current regulatory turn in international institutions, focusing on their objectives alone would offer a distorted explanation of regulations and the details of regulations growing prominence to scholars in the global South. To the the surprise in the current turn to regulatory analysis, the thing that is innovative is the drive of diverse global South scholars to borrow detailed regulatory tools that relate to their particular context. Essentially, this is what David Trubek has focused on in experimentalism. The rejection of liberal legalism as a paradigm is replaced with a critical approach as a means to eliminating those ill-suited for transplantation, and conversely, prescription where appropriate. Maybe you'll take me up on that after. But it is factually not only a description of a policy agenda, perhaps, but in terms of a factual description of what many Global South scholars engaged with development scholarship ask, that they ask for the key regulatory tools to analyze and, of course, reform from within. So just as globalization has permanently widened open the door for borrowing, allowing international actors to indefinitely push through the project of the Global South, so too are those in the South entitled to put what they want through that door into their own communities and sub-communities. In this, we have seen governments of the Global South eager to adopt regulatory frameworks associated with the regulatory state, but also witness those in the academies of the Global South and civil society experimenting with the adoption of regulatory institutions that meet particular normative goals of particular sub-communities. The Russian map exemplifies this, although seems to manifest in competing administrative agencies at the regional and federal levels rather than at some community level, although we can discuss whether that's accurate. So what does this mean? What does multiple sites of borrowing and multiple sources of borrowing mean? It means that it creates a need for a critically constructive analysis of regulatory frameworks. As communities and sub-communities seek to analyze the applicability of regulatory frameworks and forward those of interest to their goals, critical legal scholarship actually predicts that regulation will come to the forefront as the place where political tensions over economic development and ownership are expressed. When different political communities generate a plurality of solutions aimed at the promotion of their interests, then contestation over regulatory borrowing is a surety to be shifted towards political discourse. As the Russian context indicates, this does not necessarily result in productive policy action and may result in the proliferation of policy solutions from various administrative centers. However, it opens up the spaces for debate. Naturally, regulation has always been at work in development and therefore always a site of contestation. Tracing the regulatory development, regulation development context illuminates that irrespective of formal design, law reform inevitably generates what regulatory scholars would call a regulatory effect. Judicial reforms, black letter property reforms, changes to economic policy, no matter what, they engage political decision-making and address distributive effects. However, the trajectory of law and development reform also illuminates the effect to control the focus and efficiency of regulation for particular actors' benefits. And in so, it has generally ignored the political role that regulation plays in development in the Global South, as well as in the demos of the lender states in the Global North. What is common in these circumstances, excellent, as Carrie Riddick explains in regards to rights, or Jed Kronkig argues in regards to labor, is the use of substantive regulation of socioeconomic issues as an answer to a social deficit, rather than understood as a terrain of struggle. Urged forward by privatization, regulatory authorities, the codification of informal law, proliferation of regulatory techniques, they've come to adopt, states have come to adopt an institutional approach as such paper over inconvenient attempts to use regulation as sites for contestation. While this might be the governmental preference, plural regulatory borrowing or independent generation encourages contestation. So what does this mean for the methodological turn of law and development? How can we critically analyze the usefulness of regulatory structures for borrowing in a context where law and development is emerging? But perhaps more importantly, rather than borrowing, how can scholars in the Global South analyze their own regulatory structures or interpret those structures, irrespective of source, for tweaking? That we're not necessarily starting fresh every single time, as perhaps law and development scholarship and institutional scholarship around this suggests, but we need change from within. So we must begin in law and development with a better, deeper study of regulatory institutions. This is not World Bank-esque. It's a study of, not a study of inefficiencies. It's an approach that borrows, much as the Russians map, the Russian map, not the Russians map, the Russian map asks us to use an approach that borrows from the deeply descriptive regulatory scholarship to answer how these institutions work in practice and how non-state actors may fill voids left by a failing state agency. In this, the analysis of organized criminal protection that Vadim has used, or judicial discussions around that illustrate this. So socio-legal analysis has always been an integral part of law and development. This is nothing new. Galanter's anthropologically rich legal descriptions form the basis of current interest in legal actors to this day. But there could be a more focused questioning on why regulation occurs as it does, building on understanding market power, interest group theories, or stakeholder interests, as well as government opportunism, focusing on gains as well as the failures in other systems, allow us to answer whether or not normative theories of regulation are going to be effective and potentially describe internal solutions. Is this if this is experimentation's needs, of course, asking what are its problems is the key next step. Regulatory description and multiplicity of experimentation prescriptions ultimately must confront the same types of problems of power and choice engaged by universalism. Even well-chosen reforms will have unintentional effects. Who chooses which go forward? Whose interests trump? Where are they tested? Who consents? How do you legitimate negative effects? Who decides how long experimentation occurs? How do you scale up, as discussed earlier? These questions don't prevent experimentation, but they should regulate it and require us to still search for shared norms that legitimate these choices. Can regulatory analysis help us to find institutional experiences or evidences that shared norms exist under the context of institutional decision-making? Well, because I'm almost out of time, I won't go into too much detail around that, but definitely when we look into the regulatory analysis structures, we see a need to identify those shared norms. One moment, I'm going to skip quite a bit. Okay. Okay, so let me conclude there by saying that if the culture of policy analysis in Russia has been largely a classical economic analysis or a legal formalist one aimed at developmentalist goals of free market efficiencies, then a shifting focus to regulatory effects of poor state management and criminal justice may reflect its own literary preoccupations and perhaps Dostoevsky-esque focus on crime, but also a basis for exploring shared norms that may permeate through different institutions. And I think the examples provided here as the focus in on the response to government intervention seems to indicate or illustrate that. If courts are taking on a more important role in Russian disputation, then can we come around to more grounded debates yesterday raised in regards to the rule of law? If it's been fairly characterized as a loose concept or elusive by its proponents, exploitative by its critics, can a use that focuses on abusive process, even a thin formalist approach, find some purchase in the Russian context? And if so, looking to a country-specific adoption of legal and regulatory analysis. I'll end there. Thank you.
Thank you very much. Hello, good morning to all. I'd like to thank Mário and Mariana for the invitation, although I must also say that, sorry, I am no Russian scholar or Russia expert. My relations with Russia, like most other Brazilians, were basically with a very popular Russian dish we have here, which is beef stroganoff. But I've been a vegetarian for 3 years, so much for that. I enjoyed it very much. But I think, Sari's case, the invitation to me came because of my area of studies, which might and somehow add a little perspective to the paper. I am a legal historian. I study Brazilian legal history, and I am also very much interested in legal theory and legal sociology. And basically what that does to me, as mostly a historian, is to shape me up as someone who is always seeking to analyze normatively universal categories, which are basically legal categories. They have universalistic pretensions, and how they shape up and take place in local and particular and contextualized situations, which is, in my area of studies, Brazil, and the relations between law and politics in Brazil. As we could see from the paper, but mostly from the presentation, that is, in certain aspect, a perspective which was also very much present to the authors, especially in the presentation, I should say. I must also add that my comments were mostly based on the paper, and the presentation added so much to the paper, and many of the things I had in mind, I think, are not pertinent anymore because of so much of what the presentation brought to us, which it was really wonderful presentation. About the paper and about the presentation, I should say that the idea of the map of centers really struck me as a very good idea. Any of us who have been engaged in the task of looking for scholars in other areas and other locations to which we are not immediately familiar run into very big difficulties, especially if you consider the linguistic barrier, in this case, of finding trustful academics with which we could work. And the work you have done is very useful in that sense. My comment on the paper and on the presentation will be based on the perspective of what I would expect the paper to show for what I imagine its intended audience would be. And I should say a global audience, so a paper aiming at global readership. I should say that the paper should focus on highlighting local aspects that are not immediately accessible to others, especially through data and through cases. That's, I think, the big contribution that not only this paper, but all papers in a global project like this should be able to offer to each other. And in several occasions in the paper and the presentation, that does show up, and I would like to highlight some of those. First is a section which in the paper is called the historic background, which was somewhat also developed here in the presentation. My father used to say that if you're a handyman with only a hammer, everything will look like a nail to you, because you'll want to use your hammer as much as possible. So being a legal historian, obviously the historical background part of the paper impressed me, especially because it was not just antiquary information, but it was the type of historical information that tries to connect Russia's very unique historical, immediate historical background with present-day studies on law and development. In Brazil, we have a constitution that dates from 1988, and there is sometimes tendency among legal scholarship to imagine that our legal culture started in 1988 when the Constitution came into effect. And the presentation shows how relevant it is to have in mind that many of the people who are in charge of interpreting and making effective the current legal order were formed in a very different legal tradition. And that, of course, shapes their understanding of what law is, the role of law in social coordination, and the particular understanding of certain legal institutions. I think this is valid everywhere, but my impression is that this is extremely important in the Russian case, where so many institutions of what we consider to be relevant institutions for law and development must have certainly been treated and taught and reflected on in a very different manner especially in areas like private law or maybe even criminal law. So this, I think, is absolutely crucial to the paper and to the paper's success in making its point. A second comment that I would like to make is actually more based on the presentation than on the paper, and on something that struck me, especially in the first part of the presentation. The paper has a very, the authors have a very sensible effort in trying to analyze the role of law and Russia's overall political structure, I would say, including its capability of enacting and enforcing a very particular economic policy aimed towards development. I think it is relevant to bear in mind that development, the paper comments that, well, we don't have too much normative discussions on development in Russian scholarship, but I think it's safe to say, regardless of the existence of the normative discussions, that development, whatever your perspective on development is a huge, massive collective enterprise. So development can only be carried out collectively, and for this collective action to take place, a particular form, or actually many particular forms of action coordination must be present. Law is one of them, but it's not the only one. And in many circumstances, it might not have been built as the most relevant one. In Brazil today, we live day in and day out through the news of a big political corruption scandal, which can be very briefly put as an analogy with that Hollywood blockbuster, The World of Andy, I think it's called, or the movie where the guy lives in a bubble and he doesn't know he lives in a bubble, and it's like a beautiful world. Truman Show, sorry, different Jim Carrey movie. Truman Show. And the rest of the world knows that the guy lives in a bubble, and he thinks it's a beautiful, wonderful world, and there's so much going on behind. What's going on in Brazil right now sort of gives us the impression that, well, we have all these wonderful structures and everything looks so controlled, and then all of a sudden you start to figure out that the relevant means of political and economic coordination that have made the country go to where it has been. And I think that in many cases, Brazil is better now than it was 20, 25 years ago. So we are sort of, I don't know, happy, although not unconditionally happy with where the country is. And you figure out that so much of the work of coordination has been carried apart from the law, or even against the law, which can lead to two different perspectives. One is sort of a cultural perspective, like we say, oh, we Brazilians, we are uncorrectable, no law can amend this. But the other perspective is coordination has been going on, and collective action has been happening, just maybe it has been happening sort of apart from the law. In a certain sense, I think that makes it understandable, or even good, I would say, that this sort of broad scope normative discussions on development tend to show up later in countries where their particular political history maybe have made things take a different path in terms of constructing alternatives for collective action. So maybe the areas of law that are called upon are not those that we would traditionally expect to be called upon. So criminal law in Russia, for example, there has to be a particular local reason why criminal law has been so surprisingly present in development regulation, which is so particular to Russia. Maybe this happens also a little bit in Brazil, but nothing like what you described. And that obviously, that immediately makes you wonder, not if that is a problem or not, but if there's something particular about the way Russian institutions have been able to put people working together for development that has made criminal law the most attractive field of law to be called upon. What has happened? Is it because historically theoretical development on criminal law has been more thorough than, for example, in private law? That would make perfect sense for me. And this, again, is so strikingly unique, and I was very happy that the presentation was able to highlight that. How do we go about from maybe realizing that the shape or the path the practice of development took in different countries is so unique? I think the paper and Dimitri, especially part of the presentation, highlighted that, well, we have to get data and evidence, and I was very happy to see that the paper chose to bring so many different case studies that highlight so many particular aspects of how these cases were conducted in Russia. I understand this is a draft, but if I could ask of something more, or suggest something more, I should say that the amount of description and of evidence that should be brought to the readers, especially in this space, in this policy impact 3 cases, I would like as a reader to read as much on that as possible, because this is what would make the paper absolutely unique in terms of interest for a global readership. That is the type of interpretation and of information that we, as foreign scholars, would very hardly be able to gather by ourselves, and this would highlight the comparative potential of the paper with that which we see in our local jurisdictions and can read from in the other papers. So the strategy for presenting case studies is certainly very, very understandable and very useful, especially when recognizing that more in-depth theoretical study is not available in Russia scholarship. And even if it were, I'm not sure that that is what we would be eager, or not only that, we would be eager for. I mean, the evidence, the data, and the case studies would be something very, very interesting for all of us to read on. So please develop more. This is my final note on the case studies. I would thank you very much again I'd like to thank you very much again for the invitation. It was wonderful reading the paper. The presentation was especially informative of so much that appears on a nutshell in the paper. And congratulations on your effort and on the high quality of your job. So thank you very much. Is the Skype on?
Can you hear me?
Yes, I can hear you. Can you hear me?
Yes, sure. Please go ahead.
Hello?
Hello.
Okay. Hello. So,
It's your turn, please.
hi. Hi. So I just want to say good morning. It's 7 o'clock in Montreal, very cold, and I'm really sorry to have missed being part of this exciting gathering of experts on law and development from all over the world. Thanks once again for bearing with me. And the Skype connection is not very good, so if you don't hear me, please let me know. My name is Nandini Ramanujam. I'm an economist by training, and I spent years studying Russia and transition, macroeconomic transition in Russia in the 90s. And I'm particularly privileged to have the opportunity to comment on the case map, which has been prepared by colleagues from the European University of St. Petersburg. I had been involved with the early years of the university in the 90s and have known the university very well. So I'm particularly privileged. What I thought was that I've structured my brief remarks as a complement to the observations in the country map. I'd start, my point of departure is the note in the country map that the scope of law and development is anything but black letter law. In looking beyond legal documents and instruments, development must be considered within the broader system in which the letter and spirit of the law is applied or enforced. So that's my point of departure. What I'd like to do is I'd like to explore the institutional underpinnings of law and development in Russia, in what Haggard terms as the rule of law complex. What we learn is that the relationship between the rule of law and development, particularly economic development, is not about getting the law right, but rather how discrete components may come out of complex causal chain that include complementary institutions and political bargains. And I think the political bargain element is an important aspect to look at. My comments, I'd like to qualify by saying that my comments will pertain strictly to a specific aspect of development, that is economic development. I'm conscious that as I make my remarks, there is in Russia, there is a climate of economic turmoil amidst falling oil prices, dramatic depreciation in the value of the ruble, forecast of a looming economic slowdown. The extent and nature of the impact these variables will have on institutional and developmental outcomes remain to be seen. So after nearly 25 years of transition to political democracy and market economy, Russia is characterized by some weak elements of rule of law. And I just focus on some, which is lack of predictability being one, political interference in regulatory and administrative processes. I can. There was a big noise, so I stopped.
Yeah, no, you can keep going. Yeah,
you can keep
going.
Okay. Thank you. Okay, thank you. So political interference in regulatory and administrative process continue to undermine Russia's ability to realize its economic potential. In particular, I think our colleague, because I came in and out of the Skype, but I did hear a colleague from St. Petersburg speaking to the criminal law, the unreformed criminal law, the legacy of the Soviet period, and its abusive use in interference with entrepreneurial activities in particular. So I think there is a disenabling environment for entrepreneurial activities, partly due to ideological resistance and partly due to arbitrary use of criminal law, which is largely a legacy of the Soviet period. And these issues remain a significant hindrance to the development of a modern and diversified economy. Now, what I'm going to do is, since I'm conscious of time and the fact that Skype connection may not be very good, I'm going to look at a particular lens to highlight a few elements in the law and development nexus in the Russian context. And what I would like to highlight is the SME, the small and medium sector in Russia, and the fact that the economy remains undiversified. Now, the small and medium sector accounts for 20% of Russia's GDP, compared to 60% in China, 70% in the US, and in the European Union. And in order to look at it, I would use the lens of governance, which is central, in my view, to understanding the type and quality of institutions in any country. And by governance, I mean the entire way the state is run and ensures that all relevant stakeholders are adequately and equitably included. So, looking at governance, I would look at three elements and look at two sets of indicators. So the three elements are, using Leftovich's conception, systemic, political, and administrative. And the systemic aspect is governance as a regime, that is, system that incorporates and manages relationships within society, as well as sets the political and economic rules, so rules of the game. The political aspect it presupposes legitimacy of the regime, and the administrative aspect, and that is one to focus on, is a very narrow conception, but it's an efficient, independent, accountable, and open public service. And let's look at these three elements, looking at two sets of data in the context of Russia. And the data sets are the 2014 Doing Business Report, the World Bank's, and the second is the World Justice Project's Rule of Law Indicators for Russia for 2014. So it's a big surprise, because I did not look at data until I started to prepare these comments for Russia, and Russia has a record 30-place jump in the World Bank's Doing Business report. So out of 189 countries, Russia from 111 in 2013 has climbed to 62nd spot in 2014. Now, this is the data. It reduced barriers to starting business by eliminating the requirement to deposit charter capital before company registration, as well as scrapping a requirement of notifying tax authorities of new bank accounts, and made transferring property easier. Now, this is an indication of how systemic aspect of governance is making a pro-business pitch, a pro-growth effort. Now, if we just look at the rule of law indicators, which World Justice Project has reported, and looking at the 8 indicators, the picture is quite different. So constraint on government powers, Russia is 89 out of 99 countries studied. Open government, 67 out of 99. Regulatory enforcement, 67 out of 99. Criminal justice, 76 out of 99, civil justice 68 out of 99, fundamental rights 79 out of 99. So fairly low ranking in the looking through the rule of law lens. Now, I would argue that the fact that the country's continuing low score for constraints on government powers suggests that, and it is obvious that independent checks and balances on government powers are weak. Regarding the open government category, Russia's poor score reveals a fundamental weakness in legality, which is sort of using Fuller's principle. The law must be clear, understandable, constant, etc. The contradiction between doing business and rule of law indicators, to me, suggests that Russian context is marked by external opportunities and internal tensions and challenges, and this provides an impetus to examine more closely the different dimensions of rule of law and its relationship to economic development. Specifically, what factors are impacting the nexus? And I would like to quickly go over three factors. And one is the 3 factors I would look at as absence of efficient transitional institutions, informal institutions and practices, and the fourth estate, which is the... Yeah, hi. So I'm back. Yeah. As discussed in the preliminary mapping by colleagues from St. Petersburg, European University of St. Petersburg, Russia underwent a rush privatization in the 90s without adequate legal and financial infrastructure. The apparent lack of transitional institutions supporting the systemic transition during this period in Russian history may provide insights into current relationship between law and economic development in the country. Kian has argued that institutional economists have missed an important institutional dimension by failing to investigate how transitional institutions play a role in restructuring and reform in many developing economies. There is an important difference between conventional institutions and institutions in transition, in that the rules of the game in transitional institutions are dynamic. The transitional institutions find the mean to make special arrangements to compensate for institutional deficiencies and are in search of feasible, albeit imperfect, paths to making reality transition. Okay, I don't see you now. Hello?
Hello, we are here.
Can you hear me?
Yes.
Okay, so I think that would be better. I will not switch the video on.
Okay.
Yeah. So I was speaking to transitional institutions, and transitional institutions find the mean to make special arrangements to compensate for institutional deficiencies and are in search of feasible, albeit imperfect, paths to fit the economic and political realities of transition. And these institutions depend on incentives, particularly government incentives, that need to be efficiency enhancing and compatible with the interest of ruling political groups. So I would argue that the underdeveloped small and medium sector could be explained by looking at the revenue sharing arrangement between local and regional governments, which has been extensively studied by Zhuravskaya, which left no fiscal, and according to her, no fiscal incentives were left for local government to support local private firms in post-reform Russia. Further evidence suggests that if the central government takes away all locally generated revenue, there is no incentive for local governments to... Okay, thank you.
Thank you for
you. So I would argue the absence of transitional institution and the fiscal relationship between local and regional and federal governments to a great extent explains the lack of a bustling small and medium sector in Russia. So that would be my... So first was absence of transitional institution. I move on to informal institutions and practices. And it nicely segues with in a economy in transition or a society in transition, the role of informal institutions and norms. Russia, like most emerging economies, has a substantial informal sector, and looking at various data, it constitutes 49% of its official GDP. The strongest deterrent to new entry in Russia in the market remains weak property rights and contract enforcement, which represent a disjuncture between law as written and the enforcement. So the de jure and de facto law is something which is very worth looking at in the Russian context. Corruption is linked to deficiencies in law enforcement, whereby legislation can be interpreted in multiple ways and applied selectively by authorities. Poor enforcement is compounded by high levels of corruption, bribery, and capture of state processes by incumbents. So As for access to financial capital, Russian entrepreneurs, like those in countries such as India and China, rely on informal networks. In Russia, it is the informal system of agreements, exchanges of services, which in the Soviet era was known as BLAT and which still exists under in the new context. However, they have not, such informal networks have not evolved to adequately make up for formal institutional weaknesses, as they have in India and China. So rather, BLAT has devolved into a sophisticated form of corruption accessible only to the elites. It permits powerful groups to retain their stronghold and favors incumbents over newcomers, which results in disproportionate gains to elite groups. As Puffer and McCarthy argue, that the commitment and trust needed in such informal networks have eroded in Russia because of weak ties, little knowledge and information, and relatively few participants. So my last point is the fourth estate, and I am very keen to understand the relationship between the fourth estate and law and development. And amidst a highly controlled television market and few independent newspapers or radio stations in Russia, the internet in general and websites such as Rospil or Живой Жир are the likeliest places for dissent. While we may not know why or how well media and civil society foster economic development, it is almost certain that without them, there may be lost opportunities to improve political, economic, and judicial institutions that are so crucial to development. For these reasons, Russia's 2012 law, which requires nonprofit organizations to register as foreign agents with the Ministry of Justice if they engage in vaguely defined political activity and receive foreign funding, warrants particular attention. Many local and international nonprofits have argued that the law aims to demonize and marginalize civil society groups. So I would conclude by saying that over the past several years, Russia has exhibited some trends which undermine what exists of civil society organizations, political opposition, and judicial institutions. The country broadened the legal definition of treason in 2012 in a move to crack down on political opposition. This move was intended to discourage foreign aid funding to non-governmental organizations and various other third sector organizations. So I would conclude by saying that Russia is considering at this point limiting the extent to which Russians can seek judicial remedies outside Russia at the European Court of Human Rights. And amidst all this, and looking at the global trend in popular movements challenging decay in political institutions and demanding accountability from the regime, it seems that Russia cannot remain immune to such forces. The mapping of our colleagues reveal at first blush just one organization dedicated to rule of law studies, which is the Institute for the Rule of Law at the European University at St. Petersburg. And I would just propose that, there is certainly a need in Russia outside larger urban areas such as St. Petersburg and Moscow for academies to invest in studying the nuanced relationship between law development and various institutions in Russia. So I thank you for your patience, and I'm sorry for this rushed and interrupted presentation.
Thank you, Nadine, for your patience as well.
Thank you, and I wish you sunny skies in Sao Paulo. Bye-bye.
See you. I would suggest to collect some questions, and then the panelists can react to them. So Dave, Mariana, Kevin, and okay. So let's start. Dave.
So I agree with the other commentators. It's a really great presentation. But there's one thing that Raphael said that I would like to emphasize, because I think it's really very interesting and could make a big contribution to future research from your group or anyone. So Raphael points out, it's kind of a truism in the law and society tradition that, you know, the law and the action is not the same as the law in the books, and often law that appears to be regulating an area isn't doing it. And of course, there's this wonderful Brazilian expression, a law didn't take. Oh, that law didn't take, which means, you know, like a vaccination didn't take. A lei não pegou. Okay, so we know that. That's a very fundamental, you know, finding, universal finding. But once you get there, then you have to ask what did take? That is, behind a law that doesn't work, there is often something else that does. If you read Stuart Macaulay's famous article, which is kind of the origin, one of the origins of this idea, where he points out that formal contract law isn't actually governing the relationship with among corporations, but there is, he goes on to show, a whole network of social relations that explain how things get done. So it seems to me that in the sort of law and society, law and development tradition, we need to move beyond the finding, which we know we're going to find, that laws don't work as written and may not work at all, to ask what is the actual governance system, because that will tell us a lot about the development potential in a particular area.
Thank you. So as I'm looking at the country maps, it's very interesting to see that each of the maps focuses on a different legal issue, right? So when the Chinese map was presented, we saw a lot of property rights reform, securities reform, all that discussion. Then India came on board, and there was a lot of talk about the role of the judiciary and rights enforcement, the right to food, and the constitutionalization of development. And then when you guys were presenting the Russia map, I was looking at it and saying, oh, this is a whole different set of issues, because it's like how the state is promoting development, a lot of regulatory issues, so you're not necessarily, there is a lot of judicialization, but it's not necessarily constitutional like in India, but also this discussion of more basic property rights protection as in China is not there, right? And there is the criminalization. So as I'm looking to the Russian map, I see a lot of Brazil in here while you guys were presenting it, right? We're dealing with, I think the criminal law discussion is very related to Brazil. The role of the state in promoting development is very related to Brazil. The judicialization in lower courts is also, we see a lot of that in Brazil. So one question that I have regarding that is, does that tell us anything about the relevance of the political transition vis-a-vis the economic transition? Because I think Russia is a particularly interesting country because it went through an economic transition similar to China, right? It went from a communist economy into a market economy. But it sounds like what's driving a lot of your analysis is not driven by that, because the discussion of property rights enforcement and all that is not present, but instead is more the political transition that's coming to the fore here. So one question that I have is whether you guys would agree that the political dimension of the transition is playing a larger role. And the second question that I have is, while listening to you, I was seeing a lot of Brazil, and then when Andini came and made her comments, then I was like, oh, we don't have those problems, right? A lot of what she was talking about, I couldn't relate to. So the second question is how do you guys perceive what she was talking about, especially the informal networks and the lack of this institutional infrastructure to deal with the transition, especially from a legal perspective. Thank you.
Thank you. My name is Michael Riegner from Humboldt University in Berlin. You emphasized local knowledge and qualitative methods in your sociological approach to acquiring data and empirical information on as a basis for law reform, and that contrasts a little bit with, or much with, the global data sets that Nandini mentioned, in particular the doing business indicators. And I was wondering what the relative influence of these types of empirical knowledge is in policy and in the law and development discourse. And we know that doing business has serious methodological limitations, thanks to Kevin's studies, among others, but does have quite an influence in Russia, I believe, to the point that Vladimir Putin decreed that Russia needs to improve on the ranking. So what's the type of knowledge that's being produced and that is becoming policy relevant?
You got it, so. Okay. So, yeah, that was actually quite fascinating. I'm actually mainly curious about the scope of your project. First, a comment, though. I was particularly intrigued by the discussion of the information technology used in the courts, the database. And so I was wondering about the scope of that, whether it includes civil courts, first of all. And then, more generally, you mentioned that a lot of your work focuses on understanding organizational structures and incentives. And so I was wondering if you've found other instances in which it's been useful to look at mechanisms for information sharing, because in some of the work that we've done here in Latin America, looking at law enforcement institutions, one of the interesting parameters, factors that we've found is worth studying is looking at databases and the extent to which different agencies have access to common databases and the ways in which that impacts their ability to coordinate with one another. So I'm wondering if you've come across anything like that yourself. So that was just a reaction. But then I was particularly curious about whether you go beyond looking at just the legal institutions and then try to look at the effects on behavior, on primary behavior. I couldn't tell whether that was part of the project. So the effects on, say, entrepreneurs' behavior of the reforms, or the I guess in theory, effects on crime rates and so forth. So I was wondering if that's within the scope of your project or not.
Hi, John Onesorg from Wisconsin. I also thought it was a great presentation, and I thought it was really useful to bring in the basic, the way that politics function in the country right away, because I think that's really important. And I was saying to Professor Wang that it would be really interesting to do specific China-Russia, work now, comparing the way the legal systems are evolving in the two different societies. I think it'd be really interesting. There are lots of similarities. There are major differences, especially with respect to what Mariana mentioned, the transition from a Soviet economic system. The transition path has been radically different, and it seems to be affecting the way that law functions in the societies. The impact of foreign institutions like the World Bank has been radically different. So it'd be really interesting for an outsider to see good work on China and Russia comparatively. And they're also both still one-party states. And so you could have like a sub-BRICS meeting of, looking at law and development in one-party states, and South Africa could be sort of an observer because until somebody else wins an election. And it just makes them very different from India and Brazil in that respect. And I'm saying this, the East Asian thing, that the East Asian development played out in the context of these long periods of one-party rule, and I think that really, really matters for the way law functions in a society. My specific question had to do with the forest law, and that just seemed so bizarre, such a bizarre kind of reform to undertake, and I didn't get I was wondering about what the motivation for that, what drove that, in the first place, and I didn't get that. Thanks.
Thank you. Ray Guo from Renmin University of China. So this question is connected with Professor Trubek's question. So in doing law and development studies, we're often asked, like, what law doesn't work. So, I'll use a specific case. I guess it's also well known about the corporate law reform in Russia. Some of our Harvard colleagues were involved in reforming Russian corporate law, and in comparative corporate law study, that sort of Russian case sort of facilitated a big change in looking at how sort of a US-based model could be applied in the developing country to looking at the specifics and what kind of models could work. So I guess that's, so prior to the Russian case, most of the corporate law scholars would say, oh, okay, so sort of more or less US model featuring shareholder primacy could be applied in the developing country. But after the Russian case and looking at sort of how ineffective that transplantation project could be, comparative corporate law scholars switched to sort of a different mode of thinking and even proposed maybe instead of applying such a sort of US-based model, we should look at a more like self-executive model. Basically, it sort of features not offering so many of the corporate law classes with an enabling law feature, but rather switch to some of the easier to enforce. So considering the local court system and infrastructure support, so using more black letter law, using more mandatory feature law, instead of enabling law. But that's sort of what I read from the discussions in the US comparative law circle. I'm wondering what's the taking of the Russian legal academia on this incident. So what's Russian scholars' view on the failure or success of Russian corporate law? And more importantly, I guess I'm from China, so the US models are mostly working for sort of a private sector-based environment, whereas both in China and in Russia, there's a big presence of the state ownership. And the corporate law is the primary focus of corporate law in China is actually state-owned enterprises. And I suspect it probably similar in the Russian environment. So, and what's the Russian scholars taking on, the corporate law's role and what kind of models could work and reflections on the previous transplantation? Thank you.
Could you react in like 10 minutes?
Okay, 11.
David's very generous.
We demand an extra session, given the quality of your questions, the depth and perceptiveness. I'm sorry if I will not be able to address each question in full, but you are very welcome to talk in private over lunch. And we do as much as possible to to answer this question. Now, the question by David Trubek, yes, of course, we don't stop just by stating the trivial truth of legal realism. We do look at two things. Now, how law is really applied from the standpoint of interest of the agency that is responsible for its application. For example, the Russian anti-monopoly agency initiates, say 10 times more lawsuits in Russia than in United States, for example. And the targets of lawsuits are small and medium companies, and that's a paradox. And so then the study goes explaining, so what is the internal organizational and evaluation system within this agency so that it leads it to act in conflict with its nominal function. So basically, instead of pursuing large companies and initiating complex lawsuits, it just goes after very simple very simple cases. Or we look at, for example, the procedures of judicial appointment. There's a law that regulates this procedure, and there's this procedure in practice which is entirely different. And there we can find answers as to, how to explain the way judges make decisions and behave, because we look at the real filters and system of appointment, which is so very different from the law. And so on. So that's precisely our focus, but this is not the point, the major point of this presentation. Mariana, Russia, Brazil in the context of political transition. I would say yes, very much so. Political transition and the order of political transition and the intricacies of political transition plays a very important role, has maybe, if not a decisive, but a very strong effect on everything else. Connecting with the Russian-China comparison. There's a brilliant scholar, Vladimir Popov, an economist, from Moscow. He published quite a few articles. I know this. He published a book in Russian. Maybe it's translated on the comparison Russian-China transition. And the transition was very different. Russia started from, China preserved the domination of the Communist Party, the ideology of socialism, collective property, and very gradual, step by step, very cautious type of introduction of market institution, very step by step integration into the world economy, very controlled type of politics with regard to relations with global institutions. Whereas in Russia, the transition, happened in the reverse way. So liberalization came first, the collapse of the state, the political competition, political pluralism, which basically intervened with the privatization policies, because privatization couldn't be controlled, and market was introduced without proper care of market institutions, such as protection of property rights, regulations, legal environment, and the capacity of the state to protect property rights. So, which led to a very unfortunate, very skewed type of unproductive type of transition, leading to economic decline. And then from the year, from 99, basically, I think what is in the mind of President Putin and his surroundings, we have to replay it again in a different way. So back to the strong state, back to strong institutions, and then limiting the scope of rights and political competition, back to authoritarianism and developmental state. Political stability goes first, and sovereignty goes first, and economic development will follow. That's basically the current ideology. And that's what we have. On the one hand, we have developmental program based on developmental state, which does not really put emphasis on demand-driven growth, development of private business, small and medium business, and competition. Therefore, does not require all that package of institutions that are supposedly connected with the private business-driven growth, because the growth is supposed to be driven by public investments and public expenditure and institutions of development based on state corporations. So that's why the development of legal environment and the quality of legal institutions, it is recognized, but it's still of secondary policy importance for development, and that's why that's where lies the hope. I mean, now with the decline of oil prices and the kind of sobering up of the Russian government, the economy, to the real economic structure, the real need of restructuring, and to the real need of looking for other sources of federal revenue, that's where we can hope for the new sort of political orientation towards more attention to, lowering transaction costs, lowering bureaucratic burden upon business, better protection of property rights, deregulation, improvement of judicial system, constraints on the use of the criminal code, because then the state, if the political authority can accumulate rents, natural resource rents, then they don't care about the quality of the economic environment, institutional environment. Once these rents are reduced, then they start to care, that they have more incentives to care about competition and private business growth, driven growth. But still, as you know, Russia has one of the most liberal taxation codes with 30% flat income rate. All of you, probably desire such a private income tax, and rather low corporate income tax, although quite high social tax. But that condition, that liberal idea, that condition preserves. So I just mentioned two things. On the one hand, it's the reversal, an attempt to reverse the order of political transition from strong state to a more liberal and private economy oriented policies. And second, the current, if geopolitics doesn't interfere too much, we may have a kind of reorientation. Yes, Michael Ritter's question.
Yes, thank you. I would like to address Michael's question on relative importance of indicators. Much as I value doing business rating by World Bank, I think the impressive performance of Russia in 2014 should be taken with a pinch of salt, because as you correctly said, in 2012, newly elected President Putin stated that by 2018 we should move from 120th place in doing business to 20th place. So, and for this reason, a team of economists was recruited, including Semyon Dyankov from Harvard. And if you actually read the interviews of the public officials responsible for moving forward in this rating, what they did is they learned how the weights are assigned, what are the most important things to improve, and acted accordingly. I'm not saying that it was manicured growth, but as it's the key policy target, it should be taken not at face value. But regarding alternative quantitative indicators that are policy relevant, I should mention social surveys, which are secret and confidential, which are made by Federal Protection Agency, analog of Secret Service in the US. So they conduct social polls to measure social unrest. They do not publish the data, but those are the key polls used in decision-making in the Kremlin. Regarding, I also would like to address Kevin's question on the databases. First, civil courts. It depends on the definition of civil cases. If you consider arbitrage or commercial disputes, yes, every single case is in the database, starting from 2006. So there is a database. Regarding departmental databases and departmental information sharing, actually, my colleagues now are doing a project in this area. Police is not very responsive in this way, so they have their own data, which they think should be kept within the ministry, and there is a lot of synergy yet to be achieved once the information sharing process is carried on. So that's a very wonderful point that you made in this area. And I would also like just briefly address the question on the bizarreness of Forest Code of 2006 and why it happened. The reason is that the two drafts were present initially to the government, one from the Ministry of Natural Resources and the second one from the Ministry of Economic Development. And the draft that took off was from the Ministry of Economic Development. And the key reason is that Russia is a timber exporter, and forests were viewed in this draft as an economic resource to be exploited, not protected. So that's the reason. Just for the sake of brevity, I would not expand on that now. So
maybe the last one, but it's not the answer, but I lack special expertise in corporate governance. That's the Rui Ago question. But the laws on corporate governance were introduced in around 98, 99. And there were lots of problems with them, as with the bankruptcy law, because they were introduced in the context of unfinished privatization. Privatization of large enterprises in Russia did not happen in the 1990s. And this is the common pattern in Eastern Europe, so the enterprises, so from plan to clan, right? They went into the hands of the directors of enterprises and top managers, the former Soviet, the so-called red directors. So they weren't really privatized in the way that they would, get into the hands of the best owners. However, new financial industrial groups formed by the end of the 1990s that actually were looking at those enterprises, and they were better positioned to provide them resources for development. And they needed to check out these directors. And there were two laws that they were used for property redistribution. The bankruptcy law, that was an unfortunate legal transplant in 1998, that was used in a way very different from its intended use. And the second, the law of corporate governance, governance that gave rights to minority shareholders to initiate lawsuits, to basically arrest the register, to stop the whole activity of the corporation, and it gave ways to green mail and to corporate raidership. And then after assets were redistributed, then again there was consensus, okay, let's now improve the laws. Let's close all the loopholes for these raiders. And the corporate laws and the bankruptcy laws, they were amended and changed, and the new balance was achieved. The financial industrial groups got what they wanted. There were new redistribution of property, and that also provided opportunities for economic growth in the mid-2000s. That's the only competence I have, but I cannot. I don't have the the inside information about the intricacies of the law on corporate governance itself.
Thank you.
Thank you very much. Thank you for the presenters. Thank you for the discussants.